Okay, thanks very much everyone for coming along. Thank you, Drew. Afternoon, Drew. It's great to see so many of you here in person, and also we have a few people zooming in online. So thanks to all of you for being here. I want to acknowledge the Ngunnawal people whose lands we're meeting on this afternoon. And I also want to say that I'm really pleased that we're all here for Murray Thomas's final seminar. It's a great occasion to celebrate the achievement of him almost completing his PhD thesis. So this is his final seminar. It's an important milestone in the trajectory of students here at the Australian National University, and a valuable opportunity for him to share his findings and for you to ask any questions that you may have, and of course for all of us to celebrate with him what he's done so far. So Amanda is my name, Dr. Amanda Watson. I'm Murray's primary supervisor and panel chair. He also has on his panel Professor Anthony Regan and Professor Sinclair Dinnan. Sinclair has passed on his apologies. He's overseas travelling at the moment, and he's going to watch a recording of this later, and he really wanted to be here, but he has given his apologies. So our seminar today in total is 90 minutes. Definitely no more than 90 minutes, and we'll start off with Murray talking to us about his research project, and afterwards there'll be time for you to ask questions. So you're welcome to raise your hand when we get to that part of the proceedings, and if you're online you can go to the reactions section to find the raise hand function. We are recording this presentation for two reasons. First of all, the whole recording, including the question and answer component, is for Murray's use and for our use as a panel to remind ourselves of suggestions from the audience and so on. But the talk component, so not including the question and answer component, just the presentation, will also be put up on the website of the Department of Pacific Affairs. So we won't make public the question and answer section, so feel free to relax about that. So a bit about Murray before he starts. Obviously, he's a PhD candidate here at the Department of Pacific Affairs. He has a Bachelor of Economics, a Bachelor of Laws with honours, a Diploma in Strategic Studies, and a Diploma in Legal Studies. So he's worked in a range of roles, both in politics and also in law. Most recently, he worked as a prosecutor for the ACT Office of the Director of Public Prosecutions. In 2015, Murray accompanied his wife, Barbara, who's here with us today, to a posting in Port Moresby, Papua New Guinea, with the Australian government. And during her posting, he worked as a research officer in the political section of the Australian High Commission. So would you please help me to make Murray feel welcome as he begins his presentation.
Thank you, Amanda. Good afternoon, students, staff, and interested parties. My thesis chronicles and analyses the contest for the control of government, the Papua New Guinea government, in the period 1 July 2010 to 3 August 2012. It's a period that has fascinated me since I first read some Department of Foreign Affairs cables on the matter, which were really, well, good, excellent reporting. As Amanda said, I was working as a research officer in the political section at the time. In 2016, I was fortunate to attend every session of the Papua New Guinea Parliament, which really increased my interest in Papua New Guinea politics. Now, this presentation is divided into 4 topics. There's the subject matter of the thesis, there's the approach to the research, and there are answers to analytical questions. I'll come to that later. And then there is, you can relieve, a wrap-up. Now, this slide contains some images of key players in the contest for the control of the government. They are on the top left to right, Sir Michael Somare, Sapuka Temu, who gets a brief mention, and Belden Nama and Peter O'Neill. The last two get a lot of mentions. The foundation of democracy and law in Papua New Guinea is the Constitution. It came into effect on the day of Papua New Guinea's independence, which is the 16th of September 1975. It is a product of an exhaustive domestic process. The Constitution is far more detailed than, say, the Australian Constitution, and is supplemented by other lesser constitutional laws known as organic laws. Papua New Guinea has one House of Parliament, and general elections are held every 5 years. At the time of these events that I'm recounting, there were 109 members of Parliament for the 109 members of Parliament. Now, since independence, all governments have been coalitions, and for the first 25 years, the governments were very unstable. The Somare government formed after the 2002 election was the first to last for an entire term, and this success was followed up by Sir Michael returning as Prime Minister after the 2007 election. Despite this, Sir Michael had to work assiduously to shore up his support base in order to fend off motions of no confidence. Now, motions of no confidence are the Parliament's way of replacing an unpopular or out of favour PM between elections. Now, I wanted to move to the rule of law aspect of this talk. Former British Supreme Court Justice Jonathan Sumptium has suggested that the rule of law can be summed up in 3 points. 1, public authorities have no power to coerce the people other than what the law gives them. 2, people have a minimum of basic rights. And 3, they must have access to independent judges to vindicate the rights, administer the criminal law, and enforce limits on state power. Professor Yash Kai, who was a consultant in the PNG Constitutional Planning Committee, has observed that the constitutions, the Papua New Guinea Constitution, contains the following elements of the rule of law: an independent judiciary, a Bill of Rights, impartial administration of the criminal law, powers to enforce fair administration and honest public life, and a Supreme Court to determine the constitutionality of legislation, official policy, and administrative acts. In an article published in 2021, Virgil Narakobi observed that except for the events of 2011, the 3 arms of government have respected the separation of powers. That is, the powers are between the judiciary, the executive, and the Parliament, and accepted the outcome of Supreme Court cases in all the Supreme Court in all cases. Now, Mr. Narakobi's view carries some weight, as he is now a judge of the National and Supreme Courts of Papua New Guinea. My thesis seeks to meld the political and legal aspects of the contest for the control of government. I consider that this approach sort of allows for a better understanding of what happened and why things were happening. It's not something that has done, in my view, been done to the same extent in earlier accounts. Now, the contest from the thesis perspective began with the year-long disintegration of the Somare coalition government. I date the starting point as a Supreme Court decision which determined that that laws that aim to control the ability of members of Parliament to change their allegiances within a parliamentary term, it sought to control that or stop that if possible. But they declared that unlawful. And almost immediately afterwards, the Deputy Prime Minister, Sepuku Temu, left the government to mount a no-confidence motion against Sir Michael. He was unsuccessful, but from there on in, Sir Michael his Prime Ministership was essentially under constant challenge. The opposition railed against what they called the Somare Kitchen Cabinet, whereby a few ministers made all the important decisions and by implications just attracted the bulk of benefits of being in government. It sought to discredit Sir Michael by bringing up old scandals, and the opposition was given ammunition with a parade of new ones. Notably, a notable scandal was Sir Michael was found guilty by a leadership tribunal of failing to abide by his financial obligations. Some say that was important, some say not so. The government became very ragged after Sir Michael left for Singapore in March 2011 for major heart surgery. Acting Prime Minister Somare-Abal and Don Pollier ramped up their contest to succeed Sir Michael as leader of the National Alliance Party, which was the principal party in the coalition. In June 2011, Somare-Abal felt safe from a motion of no confidence, and he sacked Don Pollier and William Juma ministers and demoted Peter O'Neill from the position of Treasurer. These acts sealed the government's fate. On 2 August 2011, Belden Nama, the leader of the opposition, joined with the dissident leaders from the Somare government to choose Peter O'Neill as the new PM. The pretext was that the position of PM was vacant. Dubbed a political coup in an article of 4 August, you'll see it up the top there on the right, in a newspaper article by Isaac Nicholas of the National newspaper, the elevation of Peter O'Neill and the subsequent formation of the O'Neill-Nama government led to 12 months of political and legal turmoil. An important element of this thesis is the retreat from the rule of law. This retreat began with the coup and gathered pace as the O'Neill-Nama government became ever more aggressive in its bid to hold on to power until the start of the 2012 election. The catch cry is the parliament is supreme. The following summary of key events hopefully brings out the feverish atmosphere that prevailed. In the period August to October 2011, the East Sepik government, this is a provincial government, was threatened with the loss of its financial powers if it did not withdraw a special reference to the Supreme Court seeking the reinstatement of Sir Michael as PM. From now on, when I refer to these proceedings, I'll refer to it as the ESP case. The O'Neill-Nama government also began a campaign designed to either stop the Chief Justice of the Supreme Court, Chief Justice India, sitting on the ESP case, or to undermine his credibility as an impartial decision maker. On 6 September, Sir Michael Somare, who just returned from Singapore, was illegally ejected from the parliament. On 12 December 2011, the government, and the O'Neill-Nama government should be understood, rejected the findings of the Supreme Court in the ESP case because they said that Sir Michael was still the Prime Minister. The government then went on to suspend the Governor-General, Sir Michael Ogio, for acting on the court's decision by swearing in, he swore in Sir Michael Somare as PM. To round out 2011, the government deported, without any legal justification, a New Zealand businessman who'd allowed Somare supporters to use his premises for meetings. The new year, the government initiated proceedings before the Supreme Court, allegedly to review the ESP case decision. The real motive was to keep the question of the government's legitimacy open until the start of the 2012 election process. From now on, I'm going to refer to these proceedings as the Marat case, after the name of the Attorney General, who was Attorney General at the time. The Somare faction added its bit to the decline in respect for the law by organising a military intervention. It took place on January 2012 and was quickly quashed. The government then quickly resumed its campaign against Chief Justice India and then widened its attack on Justice Nicholas Kirilwarm. Parliament passed the Judicial Conduct Act with the intention of sidelining India and Kirilwarm from the Marat case and as a warning to other judicial officers. On 18 April, Deputy Prime Minister Narma orchestrated the passage of the Supreme Court Amendment Act, which downgraded decisions of, attempted to downgrade decisions of the Supreme Court to mere advices. Now, on 21 May, the court brought down its decision in the Marat case, and this was immediately rejected by the government. And to reinforce the point, they arrested India, Kirilwarm, and the Supreme Court Registrar and charged them with sedition. Now, Papua New Guinea's democratic processes also came under challenge. Belden Nama and Speaker of the Parliament, Jeffrey Nape, championed the idea of delaying the general election. On 5 April, a majority of parliamentarians voted to defer the election by 6 months. The attack was also on the Electoral Commission, Andrew Truen. He was criticised for his problems in trying to run the election, and he was also threatened with removal. Notwithstanding this, after a lot of political manoeuvring, the election was held on time. The O'Neill-Narmar government treated its 10 months in office as an election campaign. It spent a great deal of money on major infrastructure programs and implemented its free education promise. Peter O'Neill made sure that he was present when big projects were announced in the provinces. Towards the end of the election period, it became clear that Peter O'Neill was the leading contender for the Prime Ministership. Sir Michael Somare, together with Julius Chan and Pius Winky, both also former Prime Ministers, gave his support to O'Neill and made the prospect of O'Neill becoming a PM a near certainty. Belden Nama had hoped to become Prime Minister, but he couldn't muster sufficient support, and he'd also burnt his bridges with Peter O'Neill. New government represented more, I would say, of a realignment than a reconciliation, with Somare and his supporters joining the government and Nama and his supporters being exiled to the opposition benches. O'Neill was elected Prime Minister on the 3rd of August 2012, and the new government, and it was an O'Neill-Dion government, set about the processes of winding back all the anti-rule of law actions and legislation, and that process was more or less completed by early February 2013. Next topic, approach to the research. Research questions. The questions addressed in the thesis are the obvious: what happened? Why did a particular action occur? Then some more complex questions. Was the takeover of government lawful? Why and how did the new government remain in power? And what, if any, are the likely long-term effects on the operation of the rule of law and democracy in Papua New Guinea? Now, I've provided probably a taste of the answers to the first two questions in the outline of subject matter in the slides 4, 5, and 6. Unfortunately, time constraints don't allow for more, but I'm happy to answer questions on that issue if there was interest. I will, however, provide some more detail on the answers to the last three questions later on in the presentation. Now, PNG politics have undoubtedly been shaped by several factors. The nation started with over 800 language groups who were spread widely throughout the country. The geographic features of the country are challenging, even when distances seem modest by comparison to other countries like Australia. Researchers like Ron May, and I'll be careful because Ron is here, and Bill Standish have noted the lack of a dominant tribal group has encouraged cooperation in the country, with the catch that the focus on cooperation is achieving local rather than national objectives. This approach has inhibited economic growth. I think because the quickest return is obtained by dividing up existing resources rather than investing for the future and building resources over time. These factors have led Papua New Guinea to be known as classified as a weak or fragile state because of its difficulty in meeting the basic needs of its rather rapidly growing population. Customary practices and obligations clearly affect how people go about their daily lives, and I would say in turn how they participate in political activities. Now, in my view, there are three elements of Melanesian custom that have a most direct impact on the conduct of politics. They are the big man phenomenon, the Wontok system, and the presence of a preference for conciliation and negotiation. Professor Anthony Regan captured the essence of PNG politics in an article written in the middle of the contest for the control of government, saying, Papua New Guinea politics revolve around key personalities and patronage, with political parties of limited significance and party ideologies and policies even less so. Control of government is critical to the dispensation of patronage. Now, two people have written about the legal implications of the coup. Justice Narakobi has published two articles, and you recall in slide 3, he made his observation that the 2011 was the first time that a government had simply point blank refused to accept a constitutional ruling of the Supreme Court. In 2013, when he was a PhD student, he wrote an article analysing the ESP and Marat cases. He agreed with both decisions, but he was inclined to support a change to constitutional processes to allow a greater sort of exchange between the parliament and the courts. He appears to have been swayed by this view by the fact that although the parliament and the government refused to accept the decision of the court, Peter O'Neill still won the election, and then he was joined by his so-called opponent in the struggle for control of government. The other person who has written about this is Dr. Belkheimer, and I know he's well known here. He's argued for a greater role for the judiciary in policy making and for the doctrine of separation of powers to be updated to reflect that proposal. He has partly based these propositions on the legal arguments that were considered in the ESP and Marat cases. Dr. Keimer has attributed the resolution of the constitutional crisis to the PNG spirit of forgive and forget, aligned with the cultural values of reconciliation and consensus. Surprisingly, from my perspective, he gives no credit to the decisions of the Supreme Court. Methodology. The thesis is based on archival research and semi-structured interviews. Now, the events were covered in the 2 daily papers extensively. There were many of the court decisions and government documents were available online, which was excellent. The National Parliament's website was very useful. The only problem I had was actually getting access to daily Hansard. At key points in the contest, they just didn't exist. I was able to get some additional, copies by hiring a PNG national to go and approach the Parliament, but even then I couldn't fill all the gaps. Now, I also sought interviews from sort of past members, present members of sort of key occupational groups, the judiciary, lawyers, political advisors, party officials, politicians, public servants, military, police, academics, issue specialists, civil society representatives and journalists. 22 persons were approached for interviews, 10 persons were interviewed, and each was given a consent form to complete, which they did prior to the interview. I had 7 interviews face-to-face in Port Moresby, and I did 3 interviews, 2 with one person using Zoom, and I did also one using WhatsApp, which was easier than I thought. The interviews used open questions. The interviews were recorded and interviewees were provided with a copy of the transcript of the interview plus a copy of their consent form. They virtually all agreed that had their comments attributed to them, and there were some minor limited issues. Now, I was really privileged to obtain interviews with some people. Tiffany Twivy, who represented the O'Neill-Namar government in the Marriott case, and also wrote the, keep forgetting what the case is, we'll move on. And Dame Carol Cadu, who's of course well known, who was a minister in the Somare government at the time of the takeover and was briefly opposition leader in 2012. Ian Kemish, who was the High Commissioner for the whole of the time of the O'Neill-Namar government, and 3 senior journalists. These are some of the people, not all of them. I spoke to Frank Colmer of the National, Garethi Kenneth of the Post-Courier, and Jeffrey Alapa, who worked for both newspapers. Was the change of government lawful? Now, I say that the assertion that the office of the PM was vacant sought to sidestep 2 provisions of the Constitution. Section 145(2)(b, don't try and remember it, precludes the use of motions of no confidence to change a PM within the last year of a parliamentary term. That's to go from one PM to another PM. You can have a no confidence motion, but you can't use it to change PMs. Section 105(1)(b) provides that a successful motion of no confidence in a Prime Minister in this period, the last year of a term, brings on an early election. And this horrifies any parliamentarian because the fact is that in a general election, a large number of sitting members lose their seats. The vacancy argument was also a nonsense, as Somare-Abal was lawfully acting PM during Sir Michael's absence overseas. Similarly, the claim of legal power to declare a vacancy had no foundation. The vacancy claim was rejected by the majority of judges in the ESP case. On the eve of the handing down of that decision, the O'Neill government began to rework the arguments supporting their vacancy claim. On 9 December, the Parliament rescinded a motion which had allowed Sir Michael Somare to be absent from the May session of Parliament. By doing that, they then claimed that he had failed, he was no longer a member of Parliament because he'd missed 3 sessions of Parliament at the end of July. That's not true, but that's the claim they made. On 12 December, they applied belt and braces by amending the Prime Minister and National Executive Council Act, terminating Somare-Abal's acting appointment as Prime Minister on the basis that Sir Michael had failed to return to Papua New Guinea by the end of July. The amendment also, and this is the belt and braces, deemed valid and effective all the actions of the Speaker and the Parliament on 2 August, that's the day of the coup, with the effect from the time they occurred. The government argued in the Marriott case that the Supreme Court had failed to consider the actions of the Parliament on 9 and 12 December 2011 when ruling on the legitimacy of the government. The majority of the judges rejected this argument. The final kicker is that in 2015, the O'Neill government finally acknowledged the vacancy argument was without substance as it was a part of a compensation deal with Sir Michael Somare the settlement was recorded in the 2015 mid-year economic and fiscal report, and the relevant line item is in red, is circled in red, and I'll read it. Their sum of money was 2,490,800 kina, compensation to Sir Michael T. Somare for losses incurred during his illegal removal from office as Prime Minister and as a member for the East Sepik regional seat. Why and how did the new government remain in power? Immediately after the coup, the new government appeared to be widely accepted. Some of the explanations offered for this positive view are: Justice Kirawam, in the ESP case, argued that a few influential politicians had duped essentially the nation, using a cleverly worded motion and getting support from politicians who were panicked because Sir Michael was absent and the government was pulling itself apart from infighting. Added to this, the judiciary were initially reluctant to get involved with what they initially saw as a political issue. But really, perhaps the greatest assistance was the fact that the PNG electorate is very docile. By this I mean, most of the population are frankly preoccupied with day-to-day survival, and in any event, what happens in Port Moresby doesn't impact their daily lives, at least in an immediate sense. Public servants, police and military personnel are aware that anything other than keeping a low profile can have a adverse consequence for their career and indeed livelihood. The business community, and I don't mean this as a criticism, tends to put the highest value on stability. And finally, civil society organisations such as churches and students seem to have a high tolerance for mischief before they turn out in the streets. I guess the final argument of why it got through is that the promise of change always seems to bring out optimism in many people. The government's position started to look a lot more shaky after the ESP case. First, there was the decision itself that cast doubts on their legitimacy, and then, of course, there were days of turmoil before the government could actually reassert its control, and there were a number of days of that. If you ask why were they able to hold on to power, I would say there were four reasons. One, there was the support of a majority of members of Parliament. The Parliament is supreme. The government had the support of a majority of public service, police and military. The government was inventive in finding ways of masking or distracting attention from the issue of its legitimacy. And finally, I would say the government was prepared and showed it was prepared to do whatever it takes to stay in power. Political weaknesses in the system. Before I address the last question, I wanted to look at some, what I say of weaknesses or flaws in the political system which impede the quest for better governance. The O'Neill governments, and I include the ones after the 2012 election, confirmed that the current political system never delivers a true change of government. Any new government is essentially a rebadging of exercise, with most of the members being drawn from the former government. This continuity undermines any zeal, should I say, and scope for serious reform of PNG politics and governance. Unfortunately, over time, the political career has also become the surest path to wealth and standing. It makes it very important. Another grave flaw is the nation's big men. They carry so much weight that only they are capable of bringing about change. Between elections, the will of the people comes a very poor second to political considerations. Moreover, big men are very rarely held to account for their behaviour, no matter how egregious, and they are even less likely to be punished for the behaviour. The modern big men have significant advantages in money, education, worldly experience over most of their fellow citizens. And it's my feeling, and I'm happy to hear views to the contrary, which really enhances the cultural respect that is afforded to them in a society that's still emerging from a largely subsistence economy. Another obstacle to change is the Supreme Court's decision which stopped the controls on parliamentarians moving. I believe it's undeniable that the country is locked into a political framework which allows for tide-like movements of politicians to dictate who is PM and who is left to go on the benches, or the opposition benches. In these circumstances, Prime Ministers have little choice but to grant favours and development funds to MPs to shore up their numbers in Parliament to avoid votes of no confidence. The process is expensive and corrupts all parties. And I think the country really needs to stop worrying just about stability and also worry about how to improve governance. And finally, as I would noted, the other flaw is that the politicians take advantage of the fact that the electorate are largely docile between elections. What, if any, are the long-term likely effects of the coup? I think in 2011-12, Papua New Guinea experienced a chilling peak at how quickly the commitment to the rule of law and democracy can evaporate. Powerful persons were quick to find ways to exploit political, legal uncertainties and social angst. The legacy of the coup are the precedents that which were created. These precedents are more likely than not to encourage future politicians to ignore the national interest and engage and legal obligations in favour of personal advancement. The O'Neill Namar government indulged in crossing red lines on an industrial scale. Rule-breaking behaviour is meant to lead to adverse consequences for the perpetrators. However, no one was punished for their unlawful acts during the contest. Peter O'Neill was in fact rewarded by becoming PM after the 2012 election. The public purse bore the cost of two governments, namely the O'Neill Namar de facto government, and the costs of compensation to Michael Somare and indeed the ministers who lost their positions as a result of the coup. It takes audacity to do something that's never been done before. It's of course a lot easier to be audacious if you have confidence that there are unlikely to be any adverse consequences for your actions. I say the groundwork has been well prepared for future political adventurers. Wrap up. Nearly there. I believe that the research makes a significant contribution to the knowledge and understanding of a watershed in Papua New Guinea's history. It does confirm that societal fragmentation and the influence of geography continue to induce a preference for pursuing local interests rather than national interests. The research also highlights the central but not necessarily constructive role of big men in PNG politics. The ESP and Iraq cases have demonstrated that the provisions of the Constitution are sufficiently robust to withstand determined and ingenious challenges. And I think what has not been considered enough, it also shows the value of an independent judiciary with the courage to resist the demands for acquiescence to political objectives. It's clear, certainly to me, that the O'Neill Namar government's argument that the parliament was supreme was merely a self-serving slogan rather than a genuine view on the doctrine of the separation of powers. The political realignment that took place after the 2012 election had, in my view, more to do with political calculations than customs of reconciliation and forgiveness. And the other thing, one-top links are not necessarily determinant of political loyalties among the PNG elite. Limitations on the research and areas for future study. I wish to highlight 3 limitations. One, obviously, was the passage of time. Unfortunately, we lost a large number of important people during that time, and memories, of course, fade over time. There were key gaps in parliamentary Hansard, which was unfortunate. And I note from a personal point of view, the COVID epidemic sort of pushed back my in-country visits such that I didn't get to arrange a time in the courthouse to go through files, which I would have loved to have done. Regarding future research, I've got to confess I'm a great believer in the benefits of written histories. It's time for young researchers to take up the work of the post-World War generation, Hank Nelson, Edward Wolfers, Ron May, Bill Standish, and I should include Anthony as well, who have done some really good work, and it's a tremendous base for anybody who's doing more detailed research. Now, if general history is not your passion, I say there's a yawning gap in research on the operation and performance of PNG institutions established to hold politicians and senior officials accountable. And now for a peaceful end. In closing, thank you very much for your time spent here. I'm unsure how long I've taken, but I wanted to also express my gratitude to my panel. Dr. Amanda Watson, who has carried the main burden of steering me through the process. She's provided assistance way beyond what I have a right to expect. Professor Anthony Regan, who offered the benefits of enormous knowledge of PNG politics and constitutional law. I would hand me a document and say, you better read that. And he was right, I had to. And he also helped me to make contact with some key interviewees, as did Amanda. And finally, Professor Sinclair Dinnan graciously joined the panel late in early 2024. And his advice, which was hard to take, on writing thesis was undoubtedly made this a better product. Thank you very much, everyone.